FIR under Section 498A filed beyond period of limitation of 3 years is quashed. The matter of Kamlesh Kalra versus Shilpika Kalra and others, wherein Justice Uday Umesh Lalit and Justice Vineet Saran, the Supreme Court noted that the first information report under Section 498A of the Indian Penal Code filed by the wife 3 years later was after both separated as well as after the husband had filed a divorce petition, and that was quashed as it was filed beyond the period of limitation of 3 years, and the top court affirmed the quashing of the FIR under Section 498A of the Indian Penal Code by High Court, and the Apex Court, while allowing the appeal, also quashed the FIR under Section 406 of the Indian Penal Code. The case was that wife and husband who got married in Delhi had moved to Mumbai where they were working, but after 2 years they started living separately, and the husband filed a petition for divorce before Family Court Bandra, where the case was in its pendency. Thereafter, 3 years later, the wife filed FIR against her husband, mother-in-law, brother-in-law and sister-in-law under Section 406 and Section 498A of the Indian Penal Code, to which the respondents filed a writ petition before the High Court for quashing the FIR. The trial court framed charges under Section 406 read with Section 34 of the Indian Penal Code against husband and mother-in-law and Section 498A of the Indian Penal Code against a husband, and the High Court quashed the FIR under Section 498A of the Indian Penal Code for being filed after a period of limitation of 3 years against husband and mother-in-law. FIR against brother-in-law and sister-in-law as ineffective. FIR under Section 406 of the Indian Penal Code against the husband was quashed while keeping FIR under Section 406 of the Indian Penal Code against mother-in-law as it is, and so the mother-in-law filed an appeal by way of special leave petition before the Apex Court, where the court remarked, as regards the finding recorded by the High Court in respect to the complaint FIR filed under Section 498A of the Indian Penal Code, we are of the firm opinion that the same does not call for interference. In the facts of this case, it is clear that the FIR filed in this regard in 2015 was time barred, having been filed much more than 3 years after the separation of Manish Kalra, husband, and Shilpika Kalra, wife, and the filing of the divorce petition by the husband, both in 2009. In the facts of the case, the reasons given by the High Court for quashing the proceedings under Section 498A of the Indian Penal Code are justified and do not call for interference by this court.